Right, I think we're going to go ahead and get started. First of all, I want to thank you for taking time from your busy schedule to join Shereen and I today to talk about whistleblowing. I just want to talk about a couple of things before we get started. The American Institute of Healthcare Compliance, we encourage employers to implement good compliance programs that encourage employees to report their concerns to you. When you do this and you have the resources and the means to investigate complaints, it helps to reduce the desire of the employee to go to an outside source to whistleblow. You want to encourage people to report things that they are confident that they will be taken seriously and that some type of action. You may not agree with what they have said. You might find in your investigation that there is no nonconformance that is found, but your employees and your workforce members need to feel heard and they need to feel understood. And by doing that, it is going to lessen the chance of having a whistleblower situation in your organization. So, like I said, I'm Joanne, and I'm with the American Institute of Healthcare Compliance. And with me is Shereen Honest. And I'm going to let Shereen introduce herself.
Thank you, Joanne. It's really a privilege for me to be able to participate in this presentation with you. Uh, a little bit about me, other than my first job at Taco Bell in high school, I've been privileged to be in healthcare. I have many years of experience in compliance, operations, revenue cycle, and technology. I'm the principal at my consulting firm, The Honest Approach, and I'm the director of compliance and privacy for Archwell Health. And last but certainly not least, I am on the volunteer education committee for AIHCs. So thank you so much for everyone for joining us, and I'll turn it back over to you, Joanne.
Okay, thank you, Shereen. First, before we get into some preface and content, the information covered and discussed during the webinar today is for educational purposes only. It's not intended to be consulting or legal advice. If you have concerns after listening to today's program, you may want to consult with a professional to look at your very specific situation at your organization. There are major whistleblower cases and settlements that have been happening. And now, with the newer, just in the past year, in 2024, the DOJ has come out with additional provisions for whistleblowers. So let's take a look at in fiscal year 2024, the DOJ, Department of Justice, recovered a recorded $2.9 billion using the False Claims Act settlements and judgments, with over $1.67 billion attributed to healthcare fraud. Now, significant whistleblower cases contributed significantly to these recoveries, highlighting areas of concern such as kickbacks, unnecessary care, and opioid-related fraud. The DOJ's National Healthcare Fraud Enforcement Action exceeded $2.75 billion, and that highlights widespread fraud schemes. Endo Health Solutions settled for $475.6 million in an unsecured claim related to opioid-related fraud. Community Health Network agreed to pay $345 million settlement for kickback and Stark Law violations. Teva Pharmaceuticals paid $450 million to resolve allegations of violating the False Claims Act and anti-kickback statute, including copay assistance for Copaxone and price-fixing conspiracies. Oak Street Health paid $60 million to settle allegations of providing kickbacks to insurance agents in exchange for steering patients to their clinics. DaVita, which is the kidney dialysis company, settled for $34.5 million for kickbacks and Stark Law violations. We also have Oroville Hospital, paying $10.25 million to resolve allegations of kickbacks to admitting physicians, medically unnecessary inpatient admissions, and false diagnosis codes. There's more, but these are the more significant ones this past year, and this is why we are doing this presentation. Let's test your knowledge. I have a polling question for you. The new Corporate Whistleblower Awards program, which is the focus of today's presentation, has been launched by which government department? Is it OCR? Is it the Department of Justice? Is the Security Exchange Commission? So we have 77 people answer Department of Justice, and we have 21 said OCR, and 2% said the Security Exchange Commission, or the SEC. And the correct answer is actually the Department of Justice. So yes, the Department of Justice's Criminal Division launched the program. So first on the agenda, we're going to be covering a few basic facts about the August 2024 pilot program and the April 2025 new report portal. So there's a lot that's been going on about whistleblowing in the past year. We'll also review what the pilot program covers, which differs from the False Claims Act, how it works, incentives, and which whistleblowers are eligible for a reward. We're also going to give you a few examples of cases that fall into the pilot program criteria and end with tips on how to comply and an open Q&A session. Another poll question before we move on. How many years does this new pilot program, how many years is it launched for? Is it for 2 years? For 3 years? Is it for 5 years? It launched its program for 3 years. So the Department of Justice did this with the purpose to uncover and prosecute corporate crime. Under the pilot program, a whistleblower who provides the criminal division of the DOJ with original and truthful information about corporate misconduct, and that information results in a successful forfeiture, may be eligible for an award. The information reported must relate to one of the items listed on this slide. Number 4 relates to healthcare fraud schemes involving private insurance plans. In a healthcare organization, which professional is typically the first line of defense for your organization when systems break down? When things kind of go bad, who is the person that is typically your first line of defense? So it's 93% says the compliance officer, 6% says the CEO or practice executive, and 1% says legal counsel. When it comes to the DOJ's criminal division, they say that it's the compliance officer. Due to new developments in whistleblower protections this past year, it's evident that there's an increased federal oversight in how healthcare organizations respond to ethical and religious concerns that are raised by workforce members. It's a sign of the government's increased commitment to ensure providers and institutions uphold safety, informed consent, and respect for medical ethics. Healthcare compliance professionals are often the first line of defense when systems break down. Understanding the interplay between legal protections and organizational ethics, well, that's vital, but not only to ensure legal compliance, but also to foster environments where staff feel empowered and safe to report misconduct. Compliance officers are the ones responsible for creating and managing confidential reporting channels where employees can report potential wrongdoing without fear of retaliation. These programs should allow for anonymous reporting and ensure that all complaints are investigated promptly and fairly. They should also be designed to encourage early detection of fraud and waste. Ensure protections. So implement policies to protect whistleblowers from retaliation. This includes educating staff about their rights and providing training on identifying and avoiding retaliation. They should also work to maintain a culture where whistleblowing is encouraged and valued. That's coming from the Department of Justice. It's important to collaborate. Compliance officers should be working closely with legal, audit, and investigative teams to address reported concerns. They may also collaborate with other departments to implement corrective actions and prevent future issues. Compliance officers should regularly evaluate the effectiveness of the whistleblower program that you should have and make adjustments as needed, such as changes that have occurred just in this past year. This may involve conducting anonymous staff surveys or audits to assess the effectiveness of your current program. And needless to say, the compliance officer must stay up to date on the latest regulations and best practices related to whistleblower protection. They may also participate in continuing education, like this presentation, and networking events to enhance their knowledge and expertise, such as attending webinars and workshops and presentations like that. Another important responsibility is to educate. This involves establishing and maintaining confidential reporting mechanisms. We want to ensure the protection for whistleblowers and collaborate with other teams to address reported concerns. Many organizations establish confidential whistleblower programs that allow employees, patients, and vendors to report potential misconduct anonymously within your own organization so they don't whistleblow to an external source. These types of programs encourage early detection of fraud. As a compliance officer, be aware of the recent launch of a new whistleblower online portal, which is our next topic. The portal is where whistleblowers can submit a tip or complaint regarding the chemical and surgical mutilation of children to the Office of the Inspector General, or the OIG. This is through a presidential executive order. The portal was launched on April 14th, 2025. The law provides robust anti-retaliation protections for individuals who make reports to ensure compliance with the executive order, according to Health and Human Services. On August 1st, 2024, the Department of Justice launched the Corporate Whistleblower Awards pilot program. This program incentivizes individuals to report corporate criminal misconduct to the department by offering monetary rewards. It aims to encourage reports that might otherwise go unnoticed or be difficult to approve. This new program underscores that private payer compliance concerns cannot be dismissed or discounted. This comes on the heels of increasing state enforcement, which also looks beyond government-funded programs. I am flipping the presentation over to Shireen, who is going to finish giving her insights.
Thank you, Joanne. So the criminal division of the DOJ is staffed by career prosecutors, attorneys, and staff who serve as subject matter experts on their areas of law and criminal enforcement. They prosecute criminal matters in the federal courts and advance the department's priorities in their areas of expertise. The criminal division is a leader in the department's corporate enforcement efforts, having pioneered a corporate enforcement and voluntary self-disclosure policy in the Fraud Section's Foreign Corrupt Practices Act unit that was expanded to the criminal division in 2018. The criminal division corporate enforcement and voluntary self-disclosure policy, or CEP, served as a model for volunteer self-disclosure programs adopted across the department. While both the Corporate Whistleblower Pilot Awards and the False Claims Act, or FCA, QUITAM programs are designed to incentivize whistleblowers, they differ in scope, eligibility, and reward structure. The QUITAM program allows individuals to file lawsuits against those who defraud the government, and the whistleblowers can receive a portion of the recovered funds. The pilot program is currently in effect for 3 years, as Joanne mentioned previously. It addresses areas where the QUITAM is not applicable, particularly in corporate criminal matters, while targeting specific areas of corporate misconduct outside the purview of other whistleblower programs. including violations of the Foreign Corrupt Practices Act, bribery, and other forms of fraud. Let's take a quick look on us with a side-by-side comparison. The FCA QUITAM program really focuses on recovering funds for the government for fraudulent claims and incentivizing individuals to report fraud against government programs. Any person or entity with the knowledge of fraud can file a suit, even if they're not an employee of the company. Whereas with the Corporate Whistleblower Awards program, the focus is to really incentivize whistleblowers to report corporate misconduct that leads to successful forfeiture of assets, especially when the fraud is not covered by other whistleblower programs. And the program is really designed to fill in the gaps that the FCA in the FCA's coverage, particularly where the majority of claims are to private or non-public healthcare benefit programs. So there are many instances where both federal and private or non-public healthcare benefit programs are involved. If the majority of healthcare claims are being submitted to the private non-public healthcare benefits program, the individual can be eligible for this pilot program. Otherwise, if the majority of claims are submitted to the federal healthcare program, the individual would not be eligible for the award under the pilot program, but would need to consider filing under the QUITAM program. Next slide, please. Under the QUITAM program, a whistleblower would file a lawsuit in federal court, whereas the pilot program, the whistleblower would submit information directly to the DOJ's criminal division. In order for a whistleblower, also called a relator, to receive an award under the QUITAM program, the government must join the lawsuit that the whistleblower filed in federal court. Then the relator would be eligible to receive between 15 to 25% of the recovered funds. In the pilot program, the DOJ's criminal division can award financial incentives to whistleblowers as long as the information submitted leads to a successful forfeiture of assets. This is a discretionary award by the DOJ. Unlike some other programs, the DOJ's program does not have a freestanding whistleblower compensation fund, meaning awards are only paid from the specific cases and not from a general fund. Although more than one whistleblower can be eligible for an award, each person submitting information under the pilot program would need to provide information that is material to the investigation and which significantly contributes to successful forfeiture. If an award were to be dispensed, the whistleblower could receive a total of 30% of the first $100 million and up to 5% of the next 100 to 500 million in forfeited net proceeds. If there's more than one whistleblower, the total award cannot exceed the percentages that I just mentioned. The pilot program and related corporate enforcement policy, or CEP amendment, encourages companies to promptly self-report misconduct by adding increased pressure for compliance. The DOJ amended the CEP temporarily to run contemporaneously with the whistleblower pilot program. It allows a company to receive an internal whistleblower report to qualify for a presumption of declination if the company self-discloses the report to the DOJ within 120 days of receiving the internal report and satisfies the other applicable CEP requirements, namely providing full cooperation and timely and appropriate remediation during the investigation. The SEC, or the Security Exchange Commission, investigates violations of the securities law and pays awards to whistleblowers. Those awards through the SEC can range from 10% to 30% of the money collected in enforcement actions when over 100 million in monetary sanctions are ordered. The SEC also has protections for confidentiality of whistleblowers. The main difference between traditional SEC whistleblower cases and the new DOJ whistleblower pilot program is their scope and the type of misconduct these address. This SEC program primarily focuses on securities law violations. So next, we're going to talk about how the pilot program works. As you can see on the right-hand side of the slide, there are 10 steps to the whistleblower process. The 4 most pertinent steps are listed on the slide on the left-hand side of the slide. First, the whistleblower provides the DOJ with original, truthful information about corporate misconduct, including healthcare fraud involving private insurance plans. Then the investigation begins. If the investigation leads to successful prosecution, corporate criminal resolution, or civil forfeiture action, and the forfeiture exceeds $1 million, the whistleblower may be eligible for an award. Finally, the DOJ determines the award amount, considering factors such as the significance of the information provided, the whistleblower's assistance, and their participation in internal compliance or reporting systems. As with any other whistleblower case, it could be several years between step 1, where the whistleblower submits a tip or a complaint to the DOJ, and the final step of the award determination. A few examples of potential wrongdoing are listed on this slide. Wrongdoing could include offering or receiving kickbacks for referrals or prescriptions, false billing, such as billing for services not rendered or overbilling for services rendered. It could also include providing unnecessary or medically inappropriate services, or even fraudulent practices targeting patients, such as misrepresenting services or charging excessive fees. For example, hospital networks charging private insurers for treatments that were never performed. Some considerations to keep in mind about the new pilot program. It seeks to encourage companies to implement, maintain, and for employees to use internal reporting mechanisms. And because the whistleblower's internal report triggers a 120-day deadline for both whistleblowers and companies to report the misconduct to the DOJ to be eligible for financial awards or presumption of declination, respectively, companies have an added incentive to investigate whistleblower reports promptly and to assess their merits and decide whether to self-disclose. The new pilot program provides new incentives for workforce members or others to report so we should anticipate an increase in these types of cases. While the DOJ's whistleblower pilot program does not have supporting federal regulations prohibiting whistleblower retaliation or prohibiting companies from impeding whistleblowers from reporting concerns to authorities, both the DOJ's guidance and the program on the program itself and the program intake form invite whistleblowers to alert the DOJ of instances of retaliation or to disclose if a whistleblower has been prevented from reporting conduct about the issue. This indicates really that the DOJ wants us to be vigilant about assessing companies and how people and whistleblowers are treated. As such, entities should review internal procedures and policies regarding anti-retaliation and whistleblowing reporting. We've provided links to information about the Corporate Whistleblower Awards pilot program on this slide. The compliance officers should download and review this information, which is also posted on the webinar page of the AIHC's website. You can also use the hyperlinks on the slide or download the actual program guidance, fact sheets, and intake form from the webinar page as well. Compliance officers should access the information and consult with legal counsel or a risk attorney regarding compliance with the program. In September of 2024, the DOJ updated its guidance relating to whistleblower program in its evaluation of corporate compliance programs, the ECCP. The DOJ updated this document to encourage internal reporting of misconduct, prevent retaliation against whistleblowers, and to ensure compliance personnel have access to data and resources, including data and analytics tools. You can watch the 50-minute video on the AIHC YouTube channel entitled Compliance and the DOJ's ECCP, which was posted on January 28th of this year. The link to the video is also included on this slide. The ECCP considers how companies treat whistleblowers compared to those involved in the misconduct itself. It also emphasizes that companies should have robust policies and training to encourage whistleblowing and prevent retaliation. And the document directs prosecutors to now evaluate policies and training related to whistleblower protections and anti-retaliation. To comply with the Whistleblower Awards pilot program, providers should establish robust internal reporting mechanisms, ensure transparency, and foster a speak up culture where employees feel comfortable reporting concerns without the fear of retaliation. It is also important to review existing policies and procedures to ensure that they align with the program's expectations, including promptly investigating and reporting internal whistleblower reports to the DOJ within that 120 days that both the whistleblower and the companies have to report. Additionally, companies should emphasize anti-retaliation protections and provide thorough training on reporting mechanisms. It's important to regularly evaluate the effectiveness of the program, identify root causes of reported misconduct, and implement necessary improvements to demonstrate lessons learned. That closes my portion of the presentation. Thank you, everyone, for joining today. I'll now turn it back over to Joanne to conclude today's webinar.
Companies need to adapt compliance programs to address changes, and that includes enhancing whistleblower reporting mechanisms to ensure that compliance personnel within your organization have the necessary resources and data. Compliance officers need to be aware that they, under certain circumstances, may be eligible for whistleblower awards if they provide information about misconduct that leads to successful forfeiture. Now, before we open it up to a Q&A, it's really important to take a look at the ECCP document. And if you have time to look at the video, it's in our compliance playlist as well on the American Institute's YouTube channel. But when you have a better insight of what prosecutors look for when there's suspected wrongdoing, that helps you to make sure that you have things in place that is going to reduce your risk and mitigate the potential for there to be fines and prosecution. It's also, we have to be aware, if you're a CEO or an executive or a board member, that if a compliance officer comes to the board with a concern that they have noticed themselves or has been reported to them by a workforce member, and it is not taken seriously, and there is no action taken, and the compliance officer does not feel supported, the DOJ is encouraging compliance officers to blow the whistle on your company. So they are really going for wanting people to come forward and report. We can't function in an environment like that in healthcare. We have got to make sure that people know that everybody is doing the best they can with the resources that they have, and mistakes are made. And sometimes the mistakes are out of laziness or due to lack of resources, but most of the time, mistakes can be corrected. And that's probably the biggest defense. I did notice that there's a question about, does it have to be an anonymous system in place? I don't recall the ECCP stating that the prosecutors state that it has to be an anonymous system. But if it's not anonymous, are your workforce members comfortable reporting it without retaliation? I've worked for decades off and on in different large healthcare organizations and small ones too. And if you report a concern, it usually ends up making your life miserable. You feel retaliated against. You are overlooked for promotions. You are sometimes outcast. All kinds of things can happen. So having an anonymous method in place, you might want to encourage. If you want us to close the loop and get back to you about our activities on taking action with your complaint, then please give us your name. But if you are uncomfortable giving us your name, please report this anyway and give them an anonymous route to be able to report. I think that's probably the most important thing for the prosecutors to look at is, do you have different options for your workforce members to come forward without worrying about losing their job or being mistreated in some way? Has there been any reports made successfully so far? Um, I'm assuming under the new pilot program. I researched this last week to see if I could find any reports of violations of the new whistleblower pilot program. I did not see anything, but these things take time. Now, the pilot program is only going to be in effect for 3 years. And to tell you the truth, it's probably going to be year 2 or maybe in year 3 before we start to see the types of results from the new rule. Shireen, do you want to comment on that or expound upon that?
I agree with you, Joanne. Even now, we know that the Quitam False Claims Act cases take many, many years to go through, from the time that's reported all the way through investigation. So, with this being a brand new program, I don't think that they've, they may have some different cases that they're investigating, but I don't think they're in a point to be able to publish findings yet or to publish information because they'd want to be able to publish more specific details like they do now in their alerts and their press releases. So I think you're right. It's probably going to be a little bit longer before we start seeing anything actually published from the DOJ about this pilot program.
Thank you, Shireen. There's another question I found. Will newly announced, as of yesterday, use of FCE and Cretan provision whistleblower against DEI policies be now part of this award program? Have you heard anything about that
I
against DEI policies, Shireen?
I have not. I didn't see anything within the guidance on DEI. But I have not seen anything for this particular program.
Shireen and I can research that and
Yeah.
we'll send an email out to everybody and tell you what we find. Alrighty, and Shireen and I will get back to you in the next day or so with any other developments that we find. Things are moving pretty fast, and the government's getting very aggressive in regards to companies taking employee concerns and complaints seriously. Shireen, thank you. This was a good topic to bring up, and thank you for being on our volunteer education committee.
Thank you, Joanne. It's a pleasure. I appreciate it, and I appreciate everyone joining us today. Before we sign off, I saw one quick question that asked, are some state laws stricter? uh, I'm assuming regarding the whistleblower programs. So most states do have some form of whistleblower protections, but the scope and the strength, it's really going to be based on that particular state. So you would want to take a look at your state's laws to identify what those whistleblower uh, protections and or requirements are.
Another thing, Shireen, to expound upon what you just said, if you have providers that have malpractice insurance, you get free risk assessments and you get free advice from risk attorneys. Take advantage of that through your malpractice policy. They can come in and take a look at your whistleblower and non-retaliation program. They can give you advice. They would know what your state rules are if they are more strict than the federal rules and help to make sure that everything is aligned and it doesn't cost anything. It is part of what you're paying for in your malpractice premiums already.